Thank you, Chair. Colleagues, I'd like to start by thanking the shadow rapporteurs not only for their sound and constructive contribution to this report, but mainly for their genuine commitment and work for the protection of human rights and for combating discrimination. In 2000, I was part of a human rights organizations network that advocated for the adoption of the anti-discrimination legislation at the EU level. When the two equality directives were adopted, we considered it a historical moment, because discriminating against other human beings is one of the most despicable behavior one could imagine. 16 years later, I have the privilege, as a member of this European Parliament, to evaluate how the Employment Equality Directive has been implemented. In 2000, a duty was imposed on our member states to provide protection against discrimination in the areas of employment, occupation and vocational training. It comes as no surprise that while some member states have gone beyond its requirements by extending protection against discrimination to other areas, including access to goods and services, others are still pretty far from implementing it at a minimum level. The report highlights the necessity of collecting equality data, both at the level of member states and the European Union, in order to make it easier to prove the existence of discrimination, and particularly indirect discrimination. There is quite a discrepancy between the levels of discrimination experienced and discrimination reported. Awareness raising, with the help of equality bodies and social partners, is of utmost importance at all levels of the society, considering that the victims themselves still have difficulty in recognizing discrimination, let aside fighting it. I cannot stress enough the role of equality bodies in awareness raising and data collection, in helping the victims but also the employers to understand how to change their policies in line with the equality requirements. The impartiality of such bodies must be ensured and their activity supported, including through adequate funding. I particularly want to emphasize the issue of multiple discrimination, which often is a consequence of the existence of fragmented rules and standards across member states. If for one type of discrimination it is difficult for the victims to understand and act, we can easily imagine their difficulties when they are facing multiple discrimination. It is important to note that access to justice is still limited in many discrimination cases, and the report strongly recommends to the member states to ensure that victims can obtain accessible legal advice and assistance at all stages of the legal process, including confidential and in-person counselling by equality bodies or appropriate intermediaries. Legal redress is not only important for the victims, but it also has an educational impact on the society. Because pursuing court cases and ensuring adequate representation is still problematic in some cases, we ask the member states to find ways to help victims, including, for example, by means of court tax exemptions or reductions, legal aid and assistance from specialized NGOs. In fact, it is important to recognize that legal standing of NGOs with a legitimate interest in relevant judicial or administrative procedures. Sharing good practices among member states is a must. Acknowledging the importance of fighting all forms of discrimination, I truly hope that this House will adopt this report with a large majority. Thank you.